crime and punishment, trial and retribution. What are the separation of powers, and why are they so important to any lawful legal system? When the legislative and executive powers are united in the same person or in the same body of magistrates, there can be no liberty. And there is no liberty if the powers of judging are not separated from the legislative and the executive. There would be an end to everything if the same man or the same body were to exercise those three powers. The doctrine of the separation of powers requires that the principal institutions of the state, the legislature, the executive, and the judiciary, should be clearly divided in order to safeguard the people against tyranny by creating a system of checks and balances so that neither of these government bodies is ever allowed the unlimited power to become totalitarian. In the UK, the executive branch is made up of the government machine itself, starting with the office of the Prime Minister all the way down to the branches of local government. The legislative branch is Parliament itself, the elected House of Commons and the partly elected House of Lords. They are there to limit each other's powers and to provide for the best expertise and scrutiny of any legislation before it can be passed. The judiciary is the final branch of power, and it is made up of the court system, with the Supreme Court at the top. None of these three branches may exercise the power of the other, nor should any person be a member of any two or more of these branches. And yet, as has been pointed out by former HM Inspector and Crown Prosecutor Roger Livermore in his open letter to the current First Minister Humza Yousaf and Lord Advocate Dorothy Bain, the Scottish Government's prosecution service is headed by two government ministers. They are part of the government and can never be independent of that which they are a part of. The Crown Office and Procurator Fiscal Service is a ministerial-led government department and has no independence. It is led and staffed by government officers, and there is nothing that is independent about it. It is entirely the Scottish Government, something which Lord Advocate Bain has repeatedly misled, in other words lied, to Parliament about, which in itself is a major breach of the ministerial code which applies to all ministers, including law officers. Section 1.3c clearly states, ministers who knowingly mislead Parliament will be expected to offer their resignation. If not, the First Minister is compelled to sack them. Otherwise, they would be required to resign themselves. And therefore, ever since the devolved Scottish Parliament met for the first time on the 12th of May 1999, we have had no such separation of powers, and we have had no lawful or legal judicial system in Scotland. Its own rules render it null and void. Every court decision, ruling and conviction since May of 1999 has been executed both illegally and unlawfully. That is until Sunday the 11th of June in 2017, when the first ever common law court was convened in the historic town of Dunblane in Scotland, a court of the people, by the people and for the people. And from that day forward, the common law court has been the only lawful and legal judicial system that we have had here in Scotland, period. And since then, the common law court has not only established its position as superior to that of the statutory courts, but it has also confirmed its issued orders to be both lawful, legal, valid, and accepted as such by the statutory authorities themselves. In recent weeks and months alone, we have seen the statutory system's acceptance by an appeal judge at Her Majesty's Courts and Tribunal Services UK of a male claimant's rights of ownership to the fictitious name of a female individual. And, in another case, the acceptance of a recent CLC judgment and court order confirming the finding of guilt, the acceptance of the award for damages, and the attachment of this award to a pre-existing statutory insolvency case. This means that the state is now assisting with the enforcement and collection of a common law court award for damages. We have also seen a recent common law court convened to address the greatest crime ever perpetrated against the people in history. That is the issue of our inherent birthrights as living men and women, and of the statutory system's presumption of control, and therefore slavery. We the people, through a jury of 12 of our peers, found the named individuals representing these statutory authorities, both domestically and internationally, to be guilty of committing crimes against the people. We have also proven that all of our existing statutory bodies, courts, parliaments, MPs, police forces, local councils, and all other government institutions and offices are registered private business corporations, which are run for profit, and in being so, forfeit all of their rights of sovereignty, authority, and jurisdiction. All courts were dissolved in 2008 under the Clearfield doctrine, and became registered companies, clearly visible here on Dun & Bradstreet's Companies Search website. And once governments enter into the world of commerce, they are subject to the exact same burdens as any other private firm or corporation. This in turn means that the common law courts, Great Britain and international, are the only true, legal, lawful sovereign judicial court system currently available to living men and women in the world today. A court of the people, by the people, and for the people. We, the people. For it is in truth not for glory, nor riches, nor honours that we are fighting, but for freedom, for that alone which no honest man gives up, but with life itself. Join us at commonlawcourt.com, where you can record a public declaration of your status as a living man or woman, for preservation for all time.